Do we have everyone here for this? Okay, great, thank you.
Good morning, and may it please the court. My name is Victoria Gonzalez, and I represent the appellants James Spratlin and the law offices of Max.
I'm sorry, who, can you say your name again, please?
Victoria Gonzalez.
And I don't have you listed. I have Max Price.
I entered a notice of appearance last week, Your Honors.
Okay, I hadn't seen that. Are you with Mr. Price's firm?
Yes, Your Honor. I'm an associate with the firm.
Okay, he didn't want to show up for this, huh?
No, Your Honor, he was not able to. We had prior hearings.
That's unfortunate for you.
Your Honors, at this time, I respectfully request 3 minutes be reserved for rebuttal.
I need to, I'm sorry, I may be a little hard of hearing, so I need to ask you to speak up just a little bit or get closer to the microphone. Thank you.
No worries, my apologies.
No, it's me, I think.
Your Honors, this case is about preventing attorneys from abusing the legal system for their own personal gain and benefit. We are here today having spent judicial time, resources, and money because of Appellee's willful refusal to cash a check that was tendered without restrictions.
You know, I'm going to stop you right there because I'm speaking for myself. I don't know the position of my colleagues, but Mr. Price, first of all, he treated this money like it was his. It's not his money. It was his client's money. And there was an opinion from this court that essentially directed him, you need to pay it. This isn't your money. We rejected all those arguments. Now, I have a couple of questions, and I hope you can answer them for me. So I noticed that the notice of appeal was filed on behalf of Mr. Spratlin and also Price, correct?
Yes, Your Honor.
All right, I looked at the judgment. The judgment ordered Mr. Price to pay the $88,000 whatever in his trust account like immediately, and it's my understanding from the record that's happened, correct?
Yes, Your Honor.
Okay, so there's nothing else that judgment required him to do. On the other hand, there is still $19,000 and change outstanding, and a writ of execution was issued, according to what I've seen in the record, and that's against Mr. Spratlin for that $19,000, which I think is what we're here about today. Is that right?
Yes, Your Honor.
So really, the only party who has an interest in this appeal is Mr. Spratlin?
Your Honor, both Mr. Spratlin and the law offices, because the named parties in the final judgment was Mr. Price, which was...
Yeah, but he paid the $88,000. And the judgment wasn't against him, the judgment just directed him to release that money. But that's been done. So, and he's not challenging that,
No, Your
correct?
Honor, the only issue that we are challenging is the interest that was awarded on the $61,325.10 that had been previously tendered.
Well, again, my position is Mr. Price treated this money like it was his. It wasn't his money. He had no basis whatsoever not to just pay it. And the argument about, oh, it wasn't conditional, we just told her do it without, he had no basis to even put her in that position. So I reject all of that. So go ahead and make your argument, but I am very tuned in to the footnote. You can pass this on to Mr. Price. In our earlier opinion, I'm sorry to take this out on you. I could understand why he didn't want to show up. Where we make a comment that we were concerned about the ethics of his actions, but we didn't have to reach that issue. Well, you know what? That's not our job, but it is the bar's job. And I'm seriously thinking about whether this should be referred to the bar, and they can decide the ethics of it.
Understood, Your Honor.
And I know that's a heck of a way to get you started, but I want to let you know right away where I'm coming from.
Understood, thank you.
And I'm not speaking for my colleagues.
So on the withheld funds that was decided by the trial court, Mr. Price did give the money that he had withheld, the $27,000, and he paid the interest on that. The only reason we are here today before Your Honors is on the issue of the interest on the $61,325, because the case law states that once a party tenders payment without restrictions or conditions.
But in any of those cases, was the possibility of court and satisfaction issue raised.
Yes, Your Honors.
Okay, and doesn't that undermine the thrust of your argument that you had nothing to worry about court and satisfaction? Because this would have been a full and complete satisfaction. The fact that he tendered less than the amount that he was ordered, really, candidly, was ordered to pay. The fact that he tendered less and put in arguably a vague statement in the memo line on the check, basically, from my point of view, opens it up to leverage so that he can renegotiate with this lawyer about whatever this other dispute is that's pending down in South Florida. Well, that's the whole point of doing that.
So, Your Honor, even if the statement on the memo portion of the check itself was vague or you couldn't really understand whether it would be a court of satisfaction, Florida Statute 673.3.
The fact that you are making that argument on the other side's behalf, saying you had nothing to worry about, that opens it up for debate.
Well, no, Your Honor, because there was also accompanying correspondence and there was even an agreed order which was sent to the opposing
I
counsel.
want to just stop you because I can't get past on what basis did he have to pay anything less than the full amount? What would, regardless of a court and satisfaction, it's like theft. That wasn't his money. He withheld money that was owed to someone else. What was his basis to even withhold it to begin with? Forget a court and satisfaction. What gave him the right to withhold that money?
Your Honor, that issue was decided before the trial court, which is why he gave the money back, the 27 that he had withheld, and he gave the interest on that amount. He had before he withheld that fund though, he had given her the check for the part of the fees, the 61,000. And in the cover letter, he stated, I'm withholding the 27 as fees owed by you.
Yeah, but his whole argument here is, she should have just cashed that check for less than what she was owed.
Yes, Your Honor, because the case law.
So she did this as a self-inflicted wound. She shouldn't get interest.
Yes, Your Honor.
No, he shouldn't have tendered a check for less than this woman was owed.
Your Honor, understood, but the case law states that even if there's a dispute as to how much you owe someone, if you tender a check for less than, you're still not entitled to interest on any part of the fee that was already paid. For example, in the case of Ocean 2 Condo Association,
Wait, there was never a dispute about what she was owed for fees. That was never in dispute. The dispute has always been about interest.
Yes, Your Honor, I apologize if I misspoke. There was no dispute that she was owed the $88,600, which is the total amount, and that he sent her a check for $61,000.
He sent her a check for less than what she was owed.
The dispute, more broadly speaking, was whether or not there should be set off for what was going down in South Florida, right? Just please be candid.
Yes, Your Honor, so there is.
That's why he did it, right?
There's a separate case where he was bringing a claim for the $27,000.
But this wasn't his money.
And it wasn't that case even.
Yeah.
I understand, Your Honors, however.
I'll echo Judge Kelly's comment. I wonder at Mr. Price's continuing to litigate this issue before this court, given the bite and the obvious adversarial relationship he seems to now be in with his client, about his use of his client's money.
Well, Your Honors,
I wonder at it.
Your Honors, the reason why we're here today is because the case law and the statutes are all very clear.
We're here today because Mr. Price wanted to use his client's money, withhold some back, in order to gain leverage in a separate dispute he had in South Florida. That's why we're here.
No, Your Honor, because actually
Help me out. You just said that's why we're here. That's why you did it. So that's why we're here.
Oh, no, my apologies, Your Honor, if I misspoke. No, we're not here because of that. In fact, there was an agreed order that was sent over by Mr. Price to the appellee, which stated that he, I have the exact language.
Where in the record?
It's in the record on page 164. And there was
What page?
164 of the record.
What is it you're referring to?
It is an agreed order, proposed agreed order that Mr. Price sent over to Appellee Commons, which stated that if she stated the deposit of this check is without prejudice to the respective claims of plaintiff's counsel. And further, the stipulation of counsel and the deposit of the check shall not be deemed an admission to any pending dispute. So this agreed order would have given her the protections that she sought both in the underlying dental malpractice case.
He wouldn't
And
sign the
the-
stipulation. He would not sign the stipulation.
Yes, ma'am, so there's a
So
stipulation.
he wouldn't stipulate, and she didn't agree to this order, is that right? So it never got entered?
Yes, Your Honor, neither the stipulation nor the order was entered.
So why did he sign the stipulation? What's his excuse for that?
For the stipulation, it actually did not afford her the protections that she wanted, so she said that she wanted protections in both the dental
No,
malpractice.
why didn't he, I believe Judge Kelly can correct me, why didn't he sign the one she sent to him?
Yes, so on her stipulation, which is found on page 177 for the record, it stated that this stipulation would only apply to, quote, the case, unquote. So it would first not give her the protections that she sought in the separate Miami case. Furthermore, the stipulation in question still purported to award.
I'm kind of confused about that, so one sense, wouldn't that kind of benefit him? So if I'm correct, this is a stipulation regarding Commons' charging rate. And it says it's not in accord and satisfaction to the fee earned in this case. So
Yes.
isn't that something that, I mean, I actually have a little bit of a loss why we didn't sign that, because it seems like it confined the issue to the case, to Mr. Spracklin's case.
Yes,
And
however,
that would have been sufficient for him to, I'm not approving of what he did, but would have allowed him to, it wouldn't have had anything to do with the Miami case.
yes, but there was two
Why
separate,
wouldn't that have been satisfactory for him?
there's two separate other issues with the stipulation. First, that the stipulation still purported to award interest. The stipulation stated, and I quote, "Interest will cease to accrue on the funds paid as of the date of filing of the stipulation," which is in violation of the Florida Supreme Court's ruling.
Because it should have gone, it should have accrued from the tender.
Yes, Your Honor, that was the Supreme Court's ruling, called engineered.
So
Furthermore,
you're not disagreeing with me that the fact that it says in this case is beneficial to Ms. Price?
yes, Your Honor, however, the trial court also lacked the jurisdiction to bind Mr. Price as an extra.
You know,
agent.
and that's another thing about his argument that is just so infuriating to me. I wasn't obligated to stipulate to anything. I wasn't obligated to do it without, I didn't have any obligation to do any of that. Well, yeah, but you were obligated to pay her fee. I mean, he had no right to withhold that money. And the arrogance of his position, like, I didn't have to do anything. All I had to do is just withhold that money. And then it became her problem.
Your Honors, whether or not he should have withheld the money or not, that was an issue already decided. Our positions today is that he gave her a check for part of her fees, and under the current case law, she was entitled to cash it without it being held against her. Furthermore, aside from this agreed order, there was also in the cover letter explaining that this was only the partial fees, plus he had sent an email to the court, CC'd Ms. Commons and the JA, stating that he had no problems with her cashing the check as it would not prejudice her claim in any way, and that he would continue to have no objections. to
Yeah,
cashing
you
the
know,
check.
sending an email to the court would, especially in this situation, give me a lot of comfort if I was her.
Oh, Your Honor,
I'd feel so comfortable cashing that check.
well, Your Honor, after.
Why should she have to cash a check for less than she was owed?
Your Honor, after that email was sent, which is then when the proposed agreed order was sent over to her, which she refused to sign.
Yeah, there's been a myopic focus, and maybe it's not myopic, maybe it's dispositive, but on the accord and satisfaction statute. But you led with the more general proposition that, you know, a party is not, you know, prejudgment should not accrue if there's a tender, but that tender has to be unconditional, right? So in other words, and then from there we jump to the accord and satisfaction, and there's a lot of argument one way or the other about whether these notations on the check, et cetera, could be seen as waiving of accord and satisfaction or keeping alive accord and satisfaction expense. But isn't that a little bit of a distraction? It just has to be unconditional, and that's what we're reviewing. Was this an unconditional tender? One way it could have been less than unconditional is if it could have been supported in accord and satisfaction later. But that's one aspect of the question, but it also could be a distraction. Was this unconditional? Why was this unconditional? With all these swirling exchange of stipulations and proposed judgments and notations on checks, you explained to us why it was an unconditional tender.
Yes, Your Honor, because the term Spratlin attorney's fees, which was written on the memo portion of the check, is only a descriptive term. The case law and the statute are very clear as to what language needs to be either on.
The case law and the statute.
Yes, there's a statute, Florida statute.
Yeah, court and satisfaction statute.
Yes, which is 673.311.
Even if, are you saying categorically, if it doesn't rise to that level, it's ipso facto unconditional?
Yes,
Couldn't there also be couldn't there just be enough suspicion?
well, Your Honor, as you stated, my argument is yes, if it does not rise to that categorical level, it is not conditional. However, even if there was some debate as to whether it would or would not be, that's where the emails come in, that's where the conversations and the agreed order come in, that make it very clear, even if you do believe this contention should be a court of satisfaction, let me assure you that it's not, as it does not rise to the level of court of satisfaction, and I would not raise the defense against you should you cash it. The statute states that there can be no claim of a court of satisfaction unless there is a conspicuous statement to the effect that the
Well, you know,
text.
even in the transcript, even his arguments to the trial court, he never gives up a court of satisfaction. He dances all around that. He never gives it up. And I think that's why he didn't sign that stipulation.
Well, Your Honor, the stuff that is written down and we have in writing does show that he was willing to give up the defense of a court of satisfaction. From the email to the agreed order.
Okay, you know what? I can never get past the point that he had no business withholding that money to begin with. He had no basis to withhold that money, zero. And I can't get past that, so I can't get past that. Like the audacity.
Understood, Your
And then
Honor.
he wants to sit here and talk about, well, I unconditionally tendered like part of her fee that, you know, she's owed the whole thing. There's not like there's a dispute about that fee. He just decided, I've got this other thing and I'm gonna take care of it here because I've got this money, I'm gonna hold on to it. And hold her over a barrel and make her litigate for a fee she's already earned. Like, we're gonna go litigate it. You gotta litigate with me to get the money you're already owed, that you've ordered me to pay.
I understand your concerns, Your Honor. However, the sole issue before the court today is whether interest.
I know you keep wanting to talk about accord and satisfaction, but that is in a context, a bigger context here.
Well, Your Honor, I believe that the case law states that we can take it out of that context. All the case law, which I'd be more than happy to go through, states that
Now, I've looked at
whether there is a
it,
dispute.
it's not persuasive it's not persuasive for you.
Your Honor, the Florida Supreme Court in Poly Engineered Installation Inc. versus Hickley South Inc. made it clear that a party that owes any fees may protect itself from accrual of interest by tendering payment, and that payment can be partial payment, which is what happened in the case of Ocean 2 Condo Association, where a unit owner fell behind on the
Look.
payments.
This wasn't his money. This was Spracklin's money that Spracklin was paying, and he just had it in trust. It was not his money. It wasn't his money. It was Spracklin's money.
And the money that was given to Ms. Commons was
And
Spracklin.
Spracklin authorized the payment. Spracklin didn't dispute that he owed the $88,000. He authorized it. He signed the closing statement.
Yes, Your Honor. And
And he disregarded his client's own directive.
I think your argument had to have a little more persuasiveness, and at least for me, I could get maybe more on board with it if it were a situation where the client was saying, whoa, I don't owe that much money to
Right.
her, hold back, in which case he's kind of maybe in an interpleader kind of scenario where he just needs to get out altogether. I don't know, but that's not what happened here.
I understand Your Honor's concerns, but as I've stated before, the issue is not whether or not he should have withheld the money, whether he had the right to withhold the money or any of that. The issue is whether interest should be awarded on funds that were already previously tendered. And then, of course, the issue with that is whether it was tendered without restrictions or conditions.
You know, you're at 15 minutes if you want to save some time for rebuttal, and you can finish your answer, but I wanted to let you know before I forgot.
Thank you, Your Honor. So as I stated, the reason that we are here today is that it was tendered without restrictions or conditions, and it was made clear through the letter, a cover letter, through the emails, and to the agreed order that was sent to Ms. Collins. As such, we request that this court reverse the trial court's decision awarding prejudgment interest. Thank you, Your Honors.
Thank you.
May it please the court? I don't know that I can add anything to what this court has already said. I would
Well,
like,
it's always a dangerous thing to assume what we're thinking. You know, we may say
Yes,
a
it
lot
is.
of oral argument, but when we get back and talk about it, you never know how it's gonna turn out. So don't feel like you need to make your argument.
Why not cash the 61,000 when you had the money, bird in the hand kind of thing? Why not?
well, Ms. Collins really wanted to because she needed the money. She'd been waiting for it for quite some time. And we pleaded with Mr. Price to sign a stipulation to where that there wouldn't be any peril at all to Ms. Collins because it was already her fee. She had already earned it. In a contingency fee case, there is always a risk. And she had already endured that risk, and now it was time to get paid for that risk and for all the work that she had done. And now it was being leveraged against her in the case that Mr. Price had filed against her in Miami. In his briefs and in front of the court in his argument, he totally dances around it. He tries to play both sides of the fence. Even in the first appeal, he kept saying that there would be no harm to Ms. Collins. She was free to cash it. There was no conditions. But then he would argue just a moment later that he shouldn't have to give up that affirmative defense in Miami. So it was like that the whole time. He was always holding back a little bit while pretending to give it unconditionally. He was still adding some conditions so that he could get credit for paying it, but not have to.
Can I ask you, in our record, just in this case, and I know this has kind of been run through us a little bit before, but in this case, do we have details about that South Florida litigation? Other than what they talked about, I mean, do we have anything?
Ms. Commons has filed a counterclaim against it, and there are several things that have been pled, but Mr. Price has not pursued it at all. In fact, we came up on a lack of prosecution hearing, I think.
I'm not sure you quite understand what I'm asking.
Yes.
He wants you to stay within the record and
Oh,
In the record,
I'm
in
sorry.
this case, do we have anything along the line of what you're telling me about now? Any details, if you will, about the Miami case?
Yes, in the hearing transcript for the final judgment,
They talked
Mr.
about it.
He
Yeah,
talked
because
about
he
it,
was the plaintiff in that case, correct?
correct.
And he's talking about, I'll lose my court satisfaction defense. The court's like, well, you're the plaintiff, aren't you? Why are you worried about a defense? I
Because
mean,
there's a
he wasn't
counter-
making any sense, and then they talked about the counterclaim.
What is the counterclaim?
The counterclaim is civil theft for the fee that he has kept. There's some,
Okay, civil theft for in that case, he sues her
yes,
saying she owes him a fee.
yes,
And then the counterclaim is
is civil theft
of
and
what fee? Same fee?
the same fee.
Okay.
And she sent the letter, the notice letter, when he issued the.
The
check-
notice letter
the
being
partial-
pertaining to the civil theft notice, the statutory notice that we're talking about?
Yes, she sent the statutory notice
Is
at
this,
the time.
is this in our record?
I don't
Yes, well, it is
Did they
from,
talk, is it just insofar as they talked about it at the hearing?
correct.
Okay, but in terms of actual filings, actual stuff, it's not in our record. In
The
this
first,
case,
in the
this
first
case,
appeal, there is the,
In this case.
okay, in this case, no, they're just in his statements
Okay,
at
so
the hearing.
whenever they talk about it at the hearing,
That's the extent of what we're gonna know about the South Florida proceedings in this appeal.
That's correct.
Thank you.
Also, Mr. Price has not paid any interest on the money, even the interest that he agrees that he owes on the 27,000 disputed amount. He sent a check for that initially, but it had writings in the memo that the court had ordered that there should not be any, and that was sent back to be reissued, and he did not reissue it.
Yeah, if it doesn't mean anything, then why did you include it? Well, what I can see from our record is a writ of execution was issued on this disputed interest amount. But it was issued against Mr. Spratlin.
That's correct.
So I still don't understand what interest Mr. Price has in this appeal. If he's already done everything he was directed to do in that final judgment. There's nothing outstanding against him, right? His client's just on the hook for this disputed interest.
That
So
is
really, this appeal is about whether his client owes that additional money. I don't know, I can't tell from our record if it's been paid, and let's not go outside the record, but I can see that a writ of execution was issued against Mr. Spratlin.
Yes, Mr. Price did ultimately pay, and on the very, very last day, he paid the disputed amount and the undisputed amount, and he paid the appellate costs but he did not pay any interest on anything.
The 19,000 and change is what, when you say any interest, that's what you're referring to.
On any interest, on,
The post-judgment interest?
he's not paid any interest, pre-judgment or post-judgment, even on what he's claimed in his briefs that he agrees is owed.
I thought somewhere in the record I saw that the 88,000 that the court ordered him to disperse from his trust account, that had been done.
Yes, it has been done, but the interest that is
Is
part
the
of the judgment.
19,000
Correct,
for which the writ of execution was issued against Mr. Spratlin.
that is correct.
So it's Mr. Spratlin that owes that money.
Yes, it is. And the lower court gave Mr. Price 10 days to pay so that Mr. Spratlin would not have a judgment against him.
Right. The court was worried about the situation even getting worse for Mr. Spratlin.
And he did not. He did not make any effort to pay once.
Well, that's why we're still here litigating,
Right.
because he thinks that should never have been ordered.
Correct, even though that he admits in his briefs that he had to pay the principal and at least interest on the 27,000. He did not pay until the very, very last minute, which was months after the opinion from the first appeal. So he made no effort and refused when I approached him about it. So, we would ask, of course, that this court affirm the order of the lower court.
Thank you.
Thank you.
Got 5 minutes for rebuttal.
Thank you, Your Honors. For some clarification, yes, Mr. Price did pay, so he sent a check for the 27,000, the interest on the $27,000. However, that check was returned to him. And so she again never cashed out on either. Furthermore, this case could have been resolved if Appellee Commons had signed the agreed order, which had been sent to her on March 27 of 2020. Weeks after she, within the 90-day period when the check was still valid. And she
Wait,
had
did you call it an agreed order?
a proposed agreed order.
I don't think there was an agreement, was there?
No, Your Honor, there was called to propose agreed order because Mr. Price had sent the email to the court and CC'd Ms. Commons saying that he had no objections. And so the judicial assistant wrote back and said, if you have no objections, can you please do an agreed order and submit
You
to
know,
the
I've read
court?
through the record, I've read through the email chains, and it appears in several places in the record, and it refers to like letters and orders, and it's hard to tell what goes with what, the way that it's put together in the record.
Yes, sir.
So there's one order that's in there that's unsigned, and you're saying that that is the one that Mr. Price is proposing.
Yes, and that's found on page 164 of the record.
And I think it's on page 506 too. I mean, it's all over. the
Yeah,
place.
it's more than one place in the record. So that order came after the email from the judicial assistant saying if there's an agreement with the parties, as Mr. Price already stipulated, he has no problems with her cashing a check, and it will not prejudice her. Can you guys please do an agreed order and submit it for the judge to sign? Which is why then he prepared that order, and it was sent over to the appellee for her to sign. However, she refused to sign it. But had she signed that agreed order, it would have protected her from the claims that from a court and satisfaction. Had she signed it, she could have cashed a check, and even if for some reason later down the
So
road.
let me just, you know, I'm just in my mind, I'm thinking, okay, let's say she cashes the check for 61,000. Then what happens? What next?
Then, Your Honor, it would have only continued on the dispute of the $27,000.
Yeah, how does that get resolved? How does she get the rest of her fee that she's entitled to? How does she get that?
The cashing, she could bring her claim as she did, the cashing of the
Wait, I'm
check.
sorry. She cashes the check for 61,000, but she's owed 88,000.
Yes, Your Honor.
Okay, so she cashes it, which is what your client said she did all along. Should have done all along. So how does she get the rest of her money? What happens next after she cashes that?
After she cashes the check, she can still bring a claim before the court requesting the remainder of the
Wait, a
$27,000.
claim before what court?
Before the trial court in the dental malpractice claim or subsequent litigation, she could have brought suit against Mr. Price.
Wait, what? It's Spratlin that owes her this money, right?
Yes, Your Honor.
What, she's gonna sue her client because some other lawyer is withholding this money?
Yes, Your Honor.
How's that supposed to work? How's she supposed to get her money?
Your Honor, the same way that she did for the $27,000 in the underlying dental malpractice case, she brought a claim saying that the money should have never been withheld as it was owed to her as fees.
So, she has to, but who'd she bring that case against?
I believe it was in the same underlying dental malpractice case.
I'm sorry, what?
In the same dental malpractice case, the underlying case where she was owed the fee.
You've lost me.
In the case from which this appeal was taken?
Yes, Your Honor. The underlying case from which this appeal was taken, she was able to get her $27,000 plus interest back. The cashing of the check would have in no way hindered her ability to do so as she was able to do. And the case law states that even if she were to cash it, it would no way hinder her claims for the remainder of the fee.
So what you're saying is, having previously asserted a claim, gotten a favorable ruling, and being paid less than what she was owed on that favorable ruling, she should have just re-upped and done another claim?
No, Your Honor.
No, okay.
No, sorry, but for clarification, even if she had cashed a check, there is case law that states you can cash a check for less than what you're owed.
So in this case, the litigation regarding this matter, this dispute is ongoing. You're saying that she should have, agreed to this order, deposit the check, and the litigation in this very same case would have progressed as it did, and she would have gotten the 27,000.
Yes, Your Honor.
That's what you're saying, same case. She doesn't have to bring another action, she doesn't have to sue, she doesn't have to vindicate her claim to it in Miami, in a separate case in Miami. She does what she did do, which is get the rest of it in this case.
Yes, Your Honor, the Miami case was only brought up after there had been a dispute as to whether he had or should have withheld those funds. That only
Can
was.
you repeat that?
But the separate Miami case only arose after there began a dispute as to whether those $27,000 should have been withheld. However, the cashing of the check, she still could have, as you stated, proceeded with her claim as normal, and it would have in no way hindered her ability to gain the remainder of the $27,000.
All right, if you would like to wrap up here at the end of your time.
Yes, Your Honors. We respectfully request that this court reverse the trial court's final judgment awarding prejudgment interest on tendered funds as it directly contradicts the Florida Supreme Court's ruling in Poly Engineered. Thank you, Your Honors.
All right, thank you, and I'm really sorry for you that Mr. Price sent you up here for this. All right, that concludes our docket for today. Court is adjourned.
All rise.